Good evening, everyone. We would give a little bit more time for others to join. I'm sure the class is filled. The Zoom classroom is filled. So any other person who can join would have to go to Zoom. There's been a link that's been created on Zoom and it's been shared with your classroom. Where did we stop last week? Anybody, where did we stop?
Good evening, ma'am.
Good evening.
We stopped at commission of sales contract.
Formation. Okay, thank you very much. Thank you. Okay, so last week we talked about, last week was more like an introductory class, and we defined what sale of goods are and what types of contracts would be classified as sale of goods contracts. We also talked about the various sources of law, of sale of goods law. And so we would commence the class on sale of goods and see how far we can go with it today. And as I said earlier last week, sale of goods is a subset of contract law, which means that most of the contract law principles would also apply to sale of goods law. And sale of goods law only applies where the subject matter of the contract is goods or are goods. And we defined what goods are, and we explained what goods are not. So I'm sure you already know that. I'm not going to bore you further, with that topic. So now, I'm sure you all learned the basics of contract law, the elements of a valid contract, which is offer, acceptance, consideration, intention, and capacity. And that for an agreement to be considered enforceable, because not all agreements are enforceable. People enter into agreements every day, but not all of Nathan, come. But not all of them are enforceable. But not all of them, not all agreements are enforceable. It's only the agreements that are enforceable that are referred to as contracts. And for any sort of contract, whether it's a sale of goods contract, to be enforceable, to be valid, these elements must be there. There must be offer, there must be acceptance, consideration, intention to contract, and capacity. So that these same principles also apply in sale of goods contracts. So sale of goods contracts can be an agreement between parties where a party does not have the capacity to contract. So a minor or an infant under the law does not have capacity to enter into a sale of goods contract. So the basic rules still apply. And I'm sure that your teacher, the teacher that took you on contract has already covered the field there. So I'm not going to be repeating what offer is or what acceptance or what consideration, intention, or capacity is. If you didn't understand what you were taught, or if you were not there in class, then, read up. Information is at your fingertips. So read up and know what those things are. So the same rules that apply to the general contract law also applies to sale of goods. So if it was in a physical class, I would have probably asked you, tested your knowledge to find out and to be sure that you even understand what these basic principles are. But I'm going to be trusting that you understand what they are. Then terms of contract. I'm sure you also covered that in contract law, but it's important that we also briefly talk about it here in the aspect on sale of goods. So terms of contract, as you already know, not all statements that are made during negotiation will be referred to as terms. Terms of contracts are those legally binding, those enforceable statements that were made during negotiation. So if I'm sure today you've entered into one sort of contract or the other. You probably bought a pen, or you took a transportation here to school, or you bought food. So there must have been one sort of contract or the other that you would have formed between yesterday and today. And those terms of the contract are the promises that you exchanged. The promise that I will give you this pen that is red in color, that I'm selling to you for 100 naira, right? And you'd give me your 100 naira. Those are the terms of the contract. The terms of the contract, there are, information with respect to the pen that we agreed on, information with respect to the price. If there are other promises like Derek, pick up that thing you're sweeping off. If the other promises that we exchanged, like when we are going to be exchanging the pen, how much the denomination of the money we are going to be using to, pay for the pen should be. If there are other things that we agreed on that we know, that should be enforceable, that are legally binding, then those are referred to as terms. But the statements that were made during those negotiations that are not enforceable are referred to as mere representations. So terms can be classified into warranties and conditions. Warranties are the less important terms in the contract. Conditions are the very important terms in the contract. Warranties, example of a warranty is when I contract with you to buy and sell your pen, that a pen that has cover, right? Maybe a Snyder pen, and you sell to me a Snyder pen, but it doesn't have cover, or you sell to me a Snyder pen that is black in color, and between the two of us, we don't care whether it's actually black or blue. That term, you see, is not very important. If you don't give me the pen exactly as I wanted it, with the cover and everything, like, the color, it's not a very serious term that has been breached there. So you are not entitled to repudiate the contract, to terminate the contract and say you're not doing anymore. But if instead of giving you a pen, I give you a pencil, right? You see that I have breached a very important term, that you want a Snyder pen. But instead, I've decided to give you a Snyder pencil. You see that in that case, the term that was breached is a very important one. It goes to the very root of the contract. So it entitles me, or it entitles, the party who suffered the loss, whether it's you or I, it entitles the buyer in such a case to terminate that contract and say, I'm not doing anymore, give me back my money. Or I'm not doing anymore, I will not pay you for this contract, because the term that you breached is very serious. So aside from, the categorization of terms into warranties and conditions, terms can also come either as implied terms or as express terms. Terms can also be either implied or express. So implied terms, express terms are the terms that parties agreed upon with their words, either written words or oral words. So a term is said to be express when you and I agreed on all the terms of the contract. We said, well, you will give me a plate of rice, and that rice will have meat, it will have chicken, it will have dodo, it will have wegiri, it will have moi moi, it will have, what else? It will be hot, right? Those are the terms of the contract that we have agreed on expressly. Implied contract terms. Implied terms are the ones that we did not agree on expressly, but they have been read into the contract. So we'll see instances where terms which the parties have not agreed on expressly are read into the contract. Example, if I enter into a contract to you to sell food to you, we already agreed on the express terms, but there are some terms that will still be read into the contract. Example, terms like the food must be fresh, it must not be spoiled. The food must not have too much salt, or this food must not have maggots in it. Remember that when we're entering into this term, it's not possible for parties to agree on every term, on everything that they want in their contract. So there are terms that even though the parties did not say it with their words, whether they're oral words or they're written words, they will be read into the contract. So we would also deal with that as we go. Okay, so this is just on what we've already talked about, the warranties and the conditions. Warranties are the least important terms. They are terms that are collateral to the main purpose of the contract. So the breach of a warranty gives rise to damages only. Damages are monetary compensations, which means that if you go to court and you say that this man did not do what he said he would do, and the court would find out that that promise that he made was not a very serious promise, it was a minor promise. It was a minor term, it was a warranty. Then the court would say, okay, how can we compensate you? How can we, remedy this situation? So the court could decide to make him to do what he has said he would do, or to grant you a monetary compensation, which is referred to as damages. But the court would not allow you to terminate that contract simply because a warranty was not performed. For condition is the most important term. They often constitute the main purpose of the contract, and failure to perform a condition goes to the root of the contract, and it entitles the other party to repudiate that contract, to reject the goods, to treat the contract as repudiated. And the party also could be entitled to monetary compensation referred to as damages. So aside from the categorization, as I said already, the categorization of terms into conditions and warranties, terms can also be classified as express terms and implied terms. Express terms are agreed by the parties by their words, whether oral or written words. Implied terms are those terms that are read into the contract, either by the courts or by statutes, read the law, right? That's what we refer to as statutes, or custom and usage and trade usage. So I would break that down, or will I? Okay, no, I won't break that down. There is no need. But if you were law students, then we would have to break that down, with respect to court, statutes, and custom. And hopefully you learned that, in contract law. So terms can either be implied or read into the contract by the courts, by statute, or custom. So implied terms are things like terms that are implied by statutes, like the Sale of Goods Act implies certain terms. It implies condition as to title. I will explain that one after the other. It has an implied warranty as to title. There is the sale by sample and the sale by description, and the implied condition as to fitness and quality. So what does that mean? Section 12, subsection 1 of the Sale of Goods Act states that an implied condition says that there is an implied condition on the seller that in the case of a sale, he has a right to sell the goods. And in the case of an agreement to sell, that he will have the right to sell the good at the time property in goods is to pass to the buyer. So let me explain this subsection 1. This subsection 1 simply says that it is a condition, it is an implied condition. So you can see that in this case, this implied term is being read from the Sale of Goods Act. So there's a provision in the Sale of Goods Act that says that if you are a seller, right, there is an implied condition that you have a title, that you have a right to sell, that the goods belong to you, you have ownership of the goods that you're trying to sell. And that at least you have that title as of the time when property in goods will pass, when ownership would pass, right? So you can't sell what you don't have. You can't sell what you don't have ownership of. So because you have the pen and you're using it to write doesn't mean that it actually belongs to you. Ownership, which is referred to as title, passes when at different times we'll talk about when ownership or title passes, right? But then if you don't have ownership to something, if the pen does not belong to you, the land does not belong to you, if you don't have ownership, you can't sell it. And if you go ahead and do a jokokoro and go and sell it, there is a condition, which means that the other party can repudiate that contract, can terminate the contract and either ask for their money back, right? Or if they've not paid you anything, they can terminate and not do anything else. In some cases, they might even be entitled to the monetary compensation called damages, right? So it is an implied condition. So it's a very serious term. You not having title or ownership to sell goods is very serious. The law takes it as a very serious offense and as a very serious breach, which would entitle the buyer to terminate the contract and maybe seek damages. Section 12, subsection 2 and 3 is a different one now with respect to title, but it only says, that when you're selling goods, you must make sure that the buyer, the person that is buying it, shall enjoy quiet possession. And that the goods that you're selling to that person are free from charges and encumbrances. What that means is that if you're selling goods to somebody, one, as you can see in subsection 1, you must have good title. You can't sell what you don't have. If you don't have good title, it's the breach of a condition. 2, you must make sure that the goods that you're selling to that person, you're going to allow that person to enjoy it in peace. You're not going to be like the landlord that that will just be barging into your house anytime that they want because they feel that you're not doing the right thing. So because you've sold the pen to me doesn't mean that you'll be snatching it from me, you'll be asking me to give it back to you, and that you will not have paid everything you're supposed to pay, which means that the previous owner will come and be harassing me anyhow because you sold something to me. You must make sure that you do everything to, before you sell it to me, to make sure that I have quiet enjoyment, that people will not, because of you, be harassing me up and down. For instance, you sell a car to me, right? You must make sure that you own that car, one. And the second one, which is not as serious as the first one, is that you must make sure that I have peaceful, I have quiet enjoyment. I can enjoy that car in peace, which means that if there are things you should have done before selling that car, you should have done them. For instance, if you were supposed to have paid all your import duties, right? You should have settled all your agents that helped you to import the car, right? Then you should do it before you pass the car to me. So that it won't be that as I'm driving the car, immigration and every other person will be stopping me on the road to harass me. That's not quiet enjoyment. You have a duty as a seller to make sure that you do everything correctly, to make sure that I have quiet enjoyment as of the time that you pass the goods, and that the goods are free from encumbrances. What that means is, or charges, what that means is that you have not used that goods to go and take a loan. When you take a loan, it means that you are reducing the title of the other party. You're messing with that title of the other party. Because the bank, if you don't pay up, the bank can actually sell the goods or even take loan of it or deal with the goods in a way that is inconsistent with the ownership that you've passed to me. So, but then it doesn't mean that people don't use, goods to do as collateral. But the thing is that you must inform the other party, right? And you must make sure that whatever it is you're doing does not affect the other party's ownership or title. Does anyone have questions so far? Any questions so far?
No, ma.
Okay. So moving on. sale by sample. So this provision says that where there is a contract of sale by sample, there is an implied condition that the bulk shall correspond with the sample in quality. What happened now? Okay, so there is the implied condition. You can see that I colored the condition so that you can know the gravity of the consequence of breaching this particular term. Can someone tell me what is the consequence of breaching a condition, and what is the consequence of breaching a warranty? Let me
The
see if you guys
consequence
have been listening.
the consequence of breaching a condition is that the contract can be repudiated or terminated, while the consequence of breaching a warranty is damages.
Beautiful. Thank you for that. So some of you have been listening. So that's fine. So you can see that this second one, which is sale by sample, is also a condition, right? The first one had a part that is a condition and a part that is a warranty. This second one is entirely a condition. So if you are selling goods, you must make sure that the sample that you're using to sell the goods, that the bulk of the goods that you're selling corresponds with the sample that you showed the buyer initially. You know what it means to have sample, and you tell the person, this is the sample of what I'm going to be selling to you, right? Both of you know and agree that your transaction is based on the sample that you're going to be showing, that they've shown you, right? In such a case, there is an implied condition that all of the goods that you're going to deliver to that person must correspond with the sample that you showed. Not some of them, not in a few of them. You must correspond with the goods that you showed that person. The second one is that the buyer shall have a reasonable opportunity to compare the bulk of the goods. The buyer must have a reasonable opportunity to compare the bulk with the sample. And until he has inspected the goods, he can't be deemed to have accepted the goods. What that means is that when you're selling by sample, you as the seller, you have the responsibility to ensure that the buyer has a reasonable opportunity. It doesn't mean that you go to their house and go and kneel down or camp there and say you must check this thing before I can go. No, but you must provide that person with the opportunity to check it before you can, before that contract can be said to have been concluded, validly. So the seller has the responsibility to ensure that the buyer can confirm that the sample actually corresponds with the bulk of the goods that have been delivered. The third one is that the goods shall be free from defects, from any defects which are not obvious or unreasonable examination of the sample. So if there is anything wrong with the goods, right, and that thing that is wrong with the goods was not obvious in the sample, it was something that it was not obvious in the sample, well, you've sold it and they've now found the defect. It means that is a condition. They can repudiate that contract and ask for their money back. You have the responsibility to make sure that there is no defect in whatever you sell to the buyer, especially if it's a sale by sample. If the defect is obvious, like this one, if you see there's a caveat there that says, which is not obvious. If the defect is obvious on the face of the sample, and the buyer saw the sample with the defect as it is and still went on with the contract, then he's bound to continue with that contract. The only time he can rely on this provision is if that defect is not obvious. Then the third one is sale by description. And this is where the sale of the goods is not by sample, but by description. Section 13 provides that Section 13 of the Sale of Goods Act provides that where there is a contract for the sale of goods by description, there is an implied condition that the goods shall correspond with the description. This is also an implied condition. A sale by description is where the buyer has never seen the goods, or his decision to buy the goods are based on the description of the goods. Example, when you're buying goods over the internet. So sales by description is when you have not even seen a sample. You know, seeing a sample and touching it and feeling it and looking at it is different from when your transactional decision is solely based on the description provided by the buyer, by the seller. For instance, when you're buying things on the internet, or even when you're buying something over the phone, and the seller is describing, it's a blue phone, no, it's Samsung A22, it has this, it has that, they're describing. And so you go ahead and enter into that contract based on the description that was provided by the seller, then your sale will be considered a sale by description. Because you did not see the goods, you did not touch it, you did not feel it, you did not smell it, you didn't taste it. You know, sometimes when people go to the market to buy gari, you know, they can throw in a few into their mouth to taste it. Is it sour enough? Is it burnt? Right? Still by description, you don't have the opportunity to use any of your senses to really, except your eye. And that your eye is based on the picture that was provided by the seller, or based by the description that was provided by the seller. If, for instance, you go and buy on Temu, and I don't know if you've seen all those videos on where people are showing what they ordered and what they received. And you order for a refrigerator or a deep freezer, and instead of getting a big one that can fit in your food and your drinks, you get a miniature one that can sit on your table as a decoration. That is sale by description. You see that the picture that the seller provided, right, made it look like it's a big size goods, it's a normal size goods, but the goods itself, what was actually being sold was a miniature. So you see that in such a case, the transactional decision of the seller, of the buyer, was based on the description that was provided by the seller. So when goods are sold by description, there is an implied condition. Whether the parties put it in their contract or not, the court will read it into the contract that the description must, that the goods must correspond with the description that was provided. Implied condition as to quality and fitness. If anyone has any question at any point, please feel free to interrupt me. Implied condition as to quality and fitness. So generally, there is no implied condition or implied warranty that the goods must be of good quality or fit for any particular purpose. It is the duty of the buyer to ensure that the goods that he's purchasing has no defects, and that the goods that he's purchasing is fit for purpose, is fit for the purpose that he's purchasing it for. This is what is referred to as caveat emptor, buyers beware. I'm sure you've seen, on houses where people say caveat emptor, this house is not for sale, caveat emptor, buyers beware. Or, on the fence, they just put it there, right? They are warning you that whatever, you have a responsibility as a buyer to make sure that, that you're buying something that is of good quality. So generally, there is no such thing as implied condition or implied warranty as to quality and as to fitness of purpose. It means that whatever you go into the market and buy is what you actually, the law will take it as that is what you wanted to buy. You go into the market, you see a miniature fridge, you go and buy it. You can't come back and say, no, that's not what I wanted to buy. I actually wanted to buy a deep freezer that would fit in all my food and my drinks. Except that sale is by description or by sample. That's the only time when the court will say, okay, this sale was by description. So this person did not know that it was tiny like that because because the seller did not provide adequate information. But if it's a sale in a market or in a shop where you're seeing the goods, right? You're touching it. Whatever it is you buy, you accept that that is what you actually intended to buy. That's the general rule for caveat emptor. However, there is an exception to this caveat emptor rule in section 14 of the Sale of Goods Act. And that exception states that where the seller sells in the course of business, one, the seller must be selling in the course of business. It's not like another consumer or another student who has extra Indomie and just decides to sell it, or who has extra pen and feels he doesn't need it anymore, or who bought this shirt and feels it's not his size and he decides to sell it. They are just selling it. That's a one-off thing. They're not selling it because it's their business to sell it. They're just selling it because they have extra and they just want to get rid of it. If someone is a seller and it's their business to sell, that is one of the conditions that, before section 14 would apply. One, the seller is selling in the course of business. Two, the buyer states the purpose for which he is buying the goods. Then there shall be an implied condition that the goods must be fit for the purpose for which the goods were bought. So for instance, if you enter into a shop and you see that they're selling flour for baking, and you just go and tell them you want 2 cups of flour, you don't tell them what you want the flour for. You don't tell them what you want the flour for, right? You just tell them you want flour, they sell it to you and you go. Then when you get home, you realize that the flour that you bought is not to be used for baking, that is just to be used for frying fish. It's not to be used for baking cake. You can use it to bake puff puff or to bake bread, right? You can't go back and say, well, the flour you sold to me is not fit for the purpose that I need it for. Caveat emptor will not allow you to do that, except if you mentioned to the seller that, the only reason why I am buying this flour is because I need it to be able to bake cake. That I need it to use it and bake cake, right? You tell the seller the purpose for which you need it for, and you're relying on that seller's expertise to give you the right one. So remember that before this section 14 would apply, there are 2 conditions. What is the first condition? What's the first condition, people?
The first condition is that the seller must sell in the course of business.
Beautiful. The seller must sell in the course of business. And the second condition is what?
Is that the buyer states what he needs the goods for, the purpose for buying the goods.
Thank you. That is the only condition. That's the only condition where section 14 would apply, where the seller states, what he needs the goods for, and the buyer states what he needs the goods for, and the seller is selling in the course of business. Then the other party, the buyer, can complain that the goods that you sold to me are not fit for the purpose I need them for. For instance, you enter into a shop to buy a fan, right? The general purpose of fan is to circulate air. The general purpose for a fan is to circulate air, right? If you enter into a shop where the seller is someone that sells electronics, and you just go and pick up a fan and you get home. Meanwhile, The reason why you're buying that fan is so that you can sit in front of it and be singing and your voice will be ringing. Or because you want to set up the fan and use it to be hanging, to be drying your clothes, the clothes that you wash overnight. And when you get home, you realize that it's not the type of fan that can actually dry clothes, because it's maybe this very modern type of AC fan, right? You can't go back to the seller and tell him that, see, the fan I bought for you is not drying clothes. It's not letting me to stand in front of it and sing and my voice will ring. Because you did not tell the seller exactly what you needed the fan for. If you had told the seller, this is what I need the fan for, I want to buy it for my children so that they can be keeping themselves entertained, when they stand and they sing and their voice will be shaking, right? That is why I am buying it. And you actually go ahead and you rely on the seller's skill. And the seller say, yes, you can buy this one. Their voice will really ring when you use this one. Or no, buy that one. They will really enjoy it when you use that one. If you bought it and you relied on his skills and his judgment, then yes. If it doesn't work the way it's supposed to work, then you can reject it. You can repudiate that the goods. But if you did not, one, you did not tell him what you needed it for, and two, you told him, but you didn't rely on his opinion. He told you to buy that one and he said, don't worry, I think I will just buy this one. Or he told you to buy that one and he said, that's true. That's what my friend who sent me said I should buy this particular one. That means you're not relying on his expertise or his judgment. You're relying on your friend's expertise or judgment. In such a case, this condition would not apply. If the goods are bought by description from a seller, there is an implied condition that under section 14, subsection 2, that the goods must be of merchantable quality. Remember that before we started talking about quality, right? There is caveat emptor, buyers beware. Whatever it is you buy, is what it is that you intended to buy. However, section 14, subsection 2 now states that if you're buying by description, you didn't just enter into a shop to buy, you're buying based on the description provided by the seller, that there is an implied condition that the goods must be of merchantable quality. So when they say merchantable quality, it means good quality, right? It means good quality. So there's an implied condition that the goods are of merchantable quality, and that the goods are said to be of merchantable quality if they are fit for the purpose for which the goods of that kind are commonly used for. So if the goods are, if it's like a cooler or a fan, everybody knows that fan is generally or commonly used for blowing air. So it must be and you bought the goods by description, it must be of merchantable quality, which means it must be of good quality, and it must be able to blow air the way it's supposed to. It must be able to perform the common thing that is supposed, the common purpose that is supposed to perform, the main purpose that is supposed to perform. This condition does not apply if the defect in the goods is specifically brought to the buyer's attention before the sale, and if the buyer examined the goods before making the contract, entering into the contract, and the defect was such that should have been discovered during examination. So you see that, the courts and the law, they are interested in making sure that whatever it is you choose to do, you must do. Caveat emptor, buyers beware. It means that what this condition is stating is that if the defect was made obvious, was made known to you, you were told that, see, these goods that you're buying by description, it has one K leg there and it has one, whatever there, and you still go ahead to buy it, you can now say it's not of merchantable quality. Two, even if they didn't tell you about the defect, but the defect was obvious enough and you had the opportunity to examine the goods before buying it, then you can rely on subsection 2 of, section 14, subsection 2. Any question before we move on?
None whatsoever, ma.
Okay.
Yes, ma. Excuse me, ma. Please, I would like you to, if you don't mind, I would like you to help us proceed on that conditions you just finished explaining now, ma.
Okay. So remember that before we got there, we're talking about implied condition as to quality and fitness. And I stated that when it has to do that, there is nothing like implied condition as to quality and fitness in the first place. That there is the caveat emptor rule, buyers beware. Whatever it is you buy is what you intend. That's what they call to say that whatever it is you buy is what you intended to actually buy. You can't buy something and tomorrow you say that's not what what you sold to me is not doing what is not fit for this specific purpose that I want it to be fit for. Except you are buying from the seller and you told the seller the specific need that you need it for. And you relied on that seller's knowledge and skills. That is when you can decide that, okay, that's when you can rely on this exception in section 14. And that is for goods generally. It's not restricted to goods that are sold by description. But then, if the goods are sold by description, you can still be able to enjoy, the exception in section 14.2. So what that means is that if the goods were sold by description, you didn't have the opportunity to inspect the goods, feel it, one, the court would assume that what you couldn't inspect it, right? There is already something protecting you, saying that the goods must correspond with the description that was provided. However, if there was a defect, or if you feel that there is a specific purpose that is different from the general purpose that you need the goods for, you expected to have, one, told the seller the purpose that you want it for. If you didn't tell the seller the purpose that you want it for, then the seller does not have the responsibility to make sure that it corresponds with the purpose that you want it for, except if that purpose is a general one. If it's a special type of purpose, like the one I told you about flour, because there are different types of flour that are used in baking, right? And you didn't tell the seller that I want flour, I want to deliver flour to me, but I want the one that I can use in baking cake. Then you can't rely on whatever flour he gives you. If he gives you a multi-purpose flour, then you need to enjoy it and use it like that. You can't say the flour that he gave you is not fit for the specific purpose that you wanted it for. So the condition, does not apply where there are defects, and the defects are the type that you should have been aware of. One, where the seller told you, see, I'm selling you this goods, but this goods was, let's say this is a car. This car was accidented. That's why we're selling it to you. Which means that once they tell you the defect, it's expected that you would have considered, is this price okay or is it not okay? So you're aware of the price of the defect. So you can't now say, okay, it doesn't serve the purpose that I wanted it to serve because of the defect, when you were informed of the defect. For instance, a car, you go to buy a car in an auction, and before the auction even starts, or before the sale even starts, because we're talking of sale of goods, let's stick to sales. Before the sale starts, they tell you exactly that there was a defect, that this car was involved in an accident, and that when it was involved in that accident, it affected the bumper, the front bumper, or the mirror, the headlamp. maybe the one at the left. So they've informed you. You can't now, when you take delivery of the car, you can't go back and tell the seller, see, you sold me this car by description, but it's not fit for the purpose in which I bought it for. It is the left headlamp is not working, because remember that they informed you of the defect. So if they've informed you of the defect, you can't come and claim that the goods are not fit for purpose, or that they are not of merchantable quality. Number two is that if they didn't tell you of the defect, they didn't tell you that it's an accidented car, right? But from the description, from the picture that was posted on the website, you can already see the dent. You can see it with your own eyes that it has a dent on the bumper. Or even if you can't see it for some reason, maybe you're very careless or you were drunk, you were not looking, it's something that you should have seen if you had carefully looked, if you had examined the picture that was sent to you, or the goods that you were about to buy. It's something that you should have seen. It's not hidden. So you can't rely on the exception that says that the goods must be of merchantable quality, or that the goods must be, the goods must correspond to the purpose for which it's bought for. Is that clear? Do you understand?
Yes, ma'am. Yes, ma'am.
Okay.
Sorry, ma, I have a question.
Go ahead.
Ma, you used an example like flour, and they have different purposes for using flour. I want to ask, if it was like egg, eggs don't have description. Does it mean that if I go
Yes.
to the seller and I don't specify, because most of the times we buy eggs and we don't specify what we want to use it for. We might want to fry it or boil it or use it to bake or whatever. And I break the egg and it's bad. I go back to the seller and I return it that, look, your egg was bad. Sometimes some of them will replace it. Oh, we're sorry, I replaced the egg. Sometimes some of them will tell you they cannot replace it. Or in cases where they don't have another egg to replace it, it's not refundable. So does this mean is it like a breach of contract or warranty? Or can I hold the
Yeah,
seller responsible for not selling merchantable quality?
yes, this one is actually, this one is that, eggs is not very obvious by examining it whether it's good or bad. In respect to egg, or even watermelon, right, is what you buy that you go home and you now go and, discover that is good or is bad. But something like, let's say, what is so obvious, orange. When orange is spoiled, you smell it, you can smell that it's spoiled, you can see that it's spoiled. Or when apple is spoiled, sometimes you might be able to see that it's spoiled, sometimes you might not be able to. In such a case where by close examination you can't see the defect, then of course you can rely on the exception.
All right, thank you, ma'am.
Mm-hmm. So any other question before we move on? Okay, so now exclusion clauses. Exclusion of liability. Section 55 allows parties to expressly vary or exclude implied conditions and warranties as provided by the Sale of Goods Act. So you see that the Sale of Goods Act provides for certain implied conditions and warranties. So what the Sale of Goods Act is doing in these sections is that it's saying that even where you did not expressly agree on some terms, the Act is reading those terms into your contract, right? However, that Act is also providing the parties with the opportunity to expressly say that, you see those terms that the contract, that the Act has forced into our contract, we don't want them. So the Act under Section 55 gives you the opportunity gives you the opportunity to exclude the application of these implied terms. It gives the parties the opportunity to say, yes, we are aware that the act implies or reads some terms into the contract of sale of goods. However, we don't want it to apply to us. We don't want those implied terms to apply to us. But then you also need to be careful, because the Federal Competition and Consumer Protection Act, the act that protects consumers, that is you and I, when we buy things and we're not buying them as sellers, we are buying them to use it for our personal use as end users. When the contract, the sale of goods contract involves a consumer, the Consumer Protection Act does not allow you to exclude these implied conditions. Sale of Goods Act says you can exclude it. So it means that in your contract, you can put in a clause there that says that the terms implied by the Sale of Goods Act would not apply to this contract of sale, yeah? And it won't apply. However, you need to be careful that there might be another law somewhere that says, well, you can't enjoy this provision in section 55. Example is this Consumer Protection Act that I just told you now. So this Consumer Protection Act does not apply to all kinds of sale of goods. It only applies to sale of goods contracts or contracts that involve consumers. So if the contract is between two businesses, Consumer Protection Act does not have any business there. You can exclude liability as much as you want. But then if it has a consumer there, then you can't exclude. You must. These terms must apply to your contract. Passing of property. So under sale of goods, we've been talking a lot about when does property pass. And I told you, we agreed, I told you that property under the Sale of Goods Act simply means ownership and is different from possession. And that the primary aim of contract for sale is to transfer ownership, to transfer property from the seller to buyer. It's not it's not a contract for hire purchase or a contract for hire where you are just transferring possession. Contract for sale is different because you must be transferring ownership. You must be transferring property. So just because you have possession of something doesn't really mean that you have ownership of that thing or that you have property in goods. So why is it important to determine when property in goods pass? Because property in goods pass at different times depending on the type of goods involved. We'll get there. But why is it important to determine when property in goods pass? The first importance is that it tells you when the risks passes. So when property or title passes from the seller to the buyer, it means that the risk has now passed from the seller to the buyer, which means that if those goods become destroyed, maybe in an accident or in fire, it is whoever has property, is whoever has ownership that will bear that risk. So if the property in goods for the pen that I'm using to write still belongs to the seller, property has not passed, ownership has not passed, or I'm driving a car and I don't have ownership of it, we are still trying to sell, or we've agreed to sell, but property has not yet passed to me, and that car gets burnt, or maybe somebody robs me of that car. Under contract law, under sale of goods law, the person that will bear the risk, that will bear that liability, that will bear that loss, would be primarily the owner of the goods. not necessarily the person that is in possession. So the primary, reason why it's important to ascertain when property has passed is that ownership passes to the buyer, risk passes with property. And it's also important because the seller can actually sue the buyer if they have not paid the price. And for the seller to sue the buyer, he has to make sure that, that the goods have actually, property in the goods have actually passed. So if I'm driving the car, but the property in goods in the car has not passed, it means that, and I've not paid the seller. The seller cannot sue me until he has passed the ownership to me. It's after he has passed the ownership to me that he can now decide, to sue me for not paying the price for the car. The buyer or the owner can claim possession if the price has not been paid, but the goods has been delivered. So if the seller has delivered the car to me, but I have not paid for it, and property has passed, right? The buyer can, the owner of the car can decide to go and, if I'm not driving it, it's still with the seller, but property in goods has passed to me as the buyer, I can go and take possession. I can go and take possession of the car once I can claim that property in goods has passed to me. But, but the seller has not yet delivered the goods. So I can actually sue the seller, for having paid the price, for having gotten property in goods, but the seller has not delivered the goods to me. If the property has not passed, even if I've paid the price, right, then I can't sue until property has actually passed. So now the next question is, when can we say that property has passed from the seller to the buyer? At what point can we say that property in goods have actually passed from the seller to the buyer? So the general rule is that property in goods are transferred when the parties agree or when they intend that it should pass. So the first rule, the general rule, is that the parties have autonomy to decide. That the parties have autonomy to decide when property passes. So the parties can actually decide that property in goods, that ownership would pass in the next 5 years, not now. But they've paid the price, they've reached an agreement that in the next 5 years, property in goods will pass. They could decide that property in goods will pass now, even though the goods have not even been brought into the country. They've not even been delivered. Maybe they've not even been manufactured. So the first thing that the court would look at is, do the parties have an express intention? Did they state when they want property in goods to pass? If they stated when they want property in goods to pass, then that surpasses all other rules. However, in the absence of such an agreement, Section 16 up to Section 18 lays down rules for determining the exact time when property passes. Number one, the first question that the court would ask is, did the parties agree on when property should pass? If the answer is no, then these rules would apply. So number one is that the time property passes depends mainly on whether the goods are specific or unascertained goods. So remember that we already talked about the different types of goods. That goods could be specific goods, they could be ascertained goods, or they could be unascertained goods. So what does this even mean? Because I know some people were still confused as of that last week about the different types of goods and what they simply mean. So let me still explain again what these things are. Specific goods, please, whoever that person is, mute yourself. Specific goods are the goods that were identified and agreed upon at the time of the contract. Specific goods are the goods that were identified and agreed upon at the time of the contract. So you can see that, what determines whether goods are specific, ascertained or unascertained is how they have been identified or when they were identified, whether they were identified or when they became identified. So for specific goods is the ones that were identified at the time of the contract. For instance, you enter into a shop. Let's say you enter into ShopRite. You see a bag of rice there, right? You carry it and you put it in your cart. That is a specific goods because it's been identified and it's been agreed upon. You just take that one and you put it in your cart and you go to the counter, you pay for it. So the general rule with respect to specific goods is that where there is a contract for sale of a specific goods and is in a deliverable state, it is in a deliverable state when you can easily, move it from one person to another. Property in goods passes to that buyer when the contract is made, at the time of the contract, even if payment and delivery is being postponed. So this rule does not apply if there are unfulfilled conditions to the contract. So remember that I said specific goods are the ones that have been identified and have been set aside. And I gave you an analogy that you enter into ShopRite, you see a bag of rice, you take it and you put in your cart. That the goods have been specified because it's not among plenty goods, and then you're describing the particular one that you want and things like that. It's been specified. This is exactly what I want. I take it and I put it in my cart and I go and pay. So when the goods are specified, property in goods passes to the buyer at the time when the contract was made. And in contract law, contract is formed at this point of acceptance. So when the sale is the type that happens in a shop, when did acceptance happen? Acceptance happened when the seller accepted payment at the cashier, when the seller accepted payments. But in other circumstances, acceptance, when the acceptance happens, sometimes acceptance happens by correspondence when you tell the other party, I agree to the terms of your offer. So contracts are formed exactly at the point of acceptance. And so when the goods are specific goods, it means that property in goods passes at the time of acceptance. So it doesn't matter whether you've made payment at that point of acceptance or you've not made payments. It doesn't matter whether the goods will be delivered tomorrow, next tomorrow, in the future, or it's not been delivered, or it will be delivered now. What is important is when was the acceptance made. If I go to ShopRite and I point to the cart, to the particular thing I want, and I tell them this is the one I want, you guys deliver it to my house and I will make payments when you deliver it. That is a specific goods because it's been ascertained the specific one I want. It's been identified, right? But payment has not been made. At such a point, it doesn't matter when payment is to be made. It doesn't matter when property in goods, it doesn't matter when delivery is to be made. What is important is that acceptance, you've agreed to the term of the contract, you've agreed to it. Acceptance happened and contracts are formed at the point of acceptance. So where the contract rule 2, so that's rule 1 with respect to specific goods. Rule 2 is that where the contract is for the sale of specific goods, but the seller is to do something to put the goods in a deliverable state. Property does not pass until that thing has been done and the buyer has been notified. So if the goods are to be put in a deliverable state, maybe you're supposed to repackage it, you're supposed to put it in a type of packaging. Yes, I have agreed to buy and you have agreed to sell, but we agreed that you will package it properly. We agreed that you would do something, to put it in a deliverable state. Then property in goods does not pass at the point when the contract was formed, which is at the point of acceptance. Rather, property in goods passes when that thing that was supposed to be done has been done and the buyer has been notified. If it's been done but the buyer has not been notified, property in goods does not pass. The buyer has to be notified for property in goods to actually pass. Rule 3 is where the seller is to weigh or to measure or to test that thing, the goods, or to even do something else. If he's supposed to do something else in order to ascertain the price, right? Then property in goods would not pass until that thing has been done. However, this doesn't apply where the person who is supposed to do the measuring or the weighing or the testing is the buyer himself. For instance, I enter into ShopRite and I tell them I want this chicken here, or I want this bag of rice here. And they say, well, this is what you want, right? Okay, that's fine. We agree to sell this to you. But then we are not sure exactly how much we're going to be charging you, because we need to weigh it, because the price is determined by weighing it, by the weight. Remember that, because it's a specific goods, property in goods should have passed at the time when we agreed to buy and sell. But now something needs to be done to be able to ascertain the price. This rule 2 states that property in goods would not pass until that thing will be done by the seller, if it's the seller that needs to do it. If it's the buyer, then property in goods would pass. But if it's the seller that needs to do it, property in goods would not pass until the seller has actually weighed or measured or tested, whatever it is, in order to determine the price. Rule 4, where the goods are sold to the buyer on approval or on sale or return basis, property passes only when the buyer signifies his approval / acceptance of the goods and does any act adopting it. The second one, property in goods passes when the buyer retains the goods without giving notice until the expiration of a fixed time for the return of the goods, or beyond a reasonable time where there is no fixed time. This rule does not apply where the buyer was prevented from returning the goods by circumstances beyond his control. So let me explain this. If the goods were sold on approval, or the goods were sold on sale or return, there are certain arrangements or contracts where the parties agree that, you see these goods that you're selling, I would give you these goods. I agree to sell these goods to you and you agree to buy. However, as a distributor, you can return the goods if you don't sell them, right? You can return the goods to me if you don't sell them. I'll give you back your money. Or the other type is that I will give you these goods. I've agreed to sell these goods to you. However, before you sell it to somebody else, you need to seek my approval. So in such a case, property in goods does not pass until the buyer signifies his acceptance of the goods, until he has signify that, well, I won't be returning these goods, I accept them, right? I won't be returning this good, or even if he doesn't signify, he does something, an act showing that he has accepted it. It could be that if it's an orange, if it's a perishable, he starts to eat it. Or if it's like fabrics, he starts to cut it, to sew it. In such a case, he's already using it in a way that is showing that he has accepted it. So for property and goods to pass, the party must actually give the approval or the acceptance. And if the buyer does not give his approval or his acceptance, but he goes ahead to hold on to those goods longer than he's supposed to hold on to them. For instance, in the agreement, the buyer agreed to, the seller agreed that that the buyer can return the goods, but the buyer decided to start using the goods, or he didn't even communicate. Okay, when they agreed that you can return the goods that you've not sold, right? The seller gave him a time frame, telling him, if you don't sell these goods within 1 week, please feel free to return them. You see that there is a time frame that's been given. If he doesn't return the goods within 1 week, and he doesn't notify the seller that he's returning the goods within 1 week, then property and goods passes after that 1 week time frame, or after a reasonable time. If the agreement between them, there was no time that was agreed, then the question now is, what would the court consider a reasonable time? Property and goods passes after a reasonable time. And you can see at that last line that this rule does not apply when the buyer tried to return the goods, but he was prevented from returning the goods. He was prevented not because he was at fault, or maybe because he was stuck in traffic, but because of circumstances beyond his control. Maybe he was even arrested, out of not it being his fault, because if it's his fault, he can't rely on this. It has to be something that is not his fault. Maybe there was a lockdown because of COVID-19. Or maybe there was a fire that destroyed the goods, and he wasn't the one that caused the fire. In such a case, this rule does not apply with respect to approval or sale by return. And so we've talked about rule 1 to rule 4, and they are all the rules that applied when the goods are specific goods. So the next question is that where the goods are not specific goods, but they are unascertained goods. Property does not pass to the buyer until the goods become ascertained. So what does it mean for goods to be unascertained or for goods to be ascertained? So ascertained goods are goods that were initially unascertained, but later became identified and set aside for the contract, right? Let me give you an example. You go into a warehouse where they sell rice, and there are plenty bags of rice. And you tell the seller, I want 20 bags of rice, or I want 10 bags of rice. And let's say that there are 100 bags in the warehouse. And you people agree, you sign the contract, maybe you even pay the money because I want 10 bags of rice, of this rice in your warehouse. The goods that you've paid for are not ascertained goods yet. In fact, they are unascertained goods because they have not been identified or set aside from the bulk. They become ascertained when they are set aside, when they go into somebody goes, maybe one of the employees there, go into that warehouse, and from that whole 100 bags of rice, they bring out 10 bags and set it aside for you and tell you these 10 bags have been set aside for you. These are the ones we'll send to you. So once they set it aside for you, they have become ascertained goods. Unascertained goods is that people have agreed, but they've not been set aside. So the rule with respect to unascertained goods is that property does not pass until they become ascertained, until they are set aside, until they are, identified and set aside for you. That is only when property in goods, when ownership passes, and that's rule 5. In contract, for a sale of future goods or unascertained goods for property in goods to transfer, right? The buyer, one, for property in goods to transfer in unascertained goods, it must be set aside and it must be identified and set aside, which means it must become ascertained. However, if something needs to be done in order to put it in a deliverable state, then property in goods does not pass until that thing has been put in a deliverable state. Which means that if you enter into a contract for someone to deliver, let's say 100 school uniforms to you next term, those are future goods, right? The rule is that whether they are future goods or goods that are unascertained, like the one in the warehouse I just described to you, right? Property in goods does not pass until they have become ascertained, until they have been, they have been unconditionally appropriated. They have, when you mean unconditionally appropriated, you've brought them out ready to deliver them. Or you have put them in a deliverable state. If you need to put them in any sort of packaging, if you need to do anything to put it in a deliverable state, until that has been done, property in good does not pass. But remember that these rules only apply where the parties did not expressly agree on when property will pass. If in their contract for future goods, for the school uniform, they agreed that ownership would pass to the buyer at the point of sale, maybe at the time when payment is made, or at the time when the other party agrees. It's stated there in their contract. They are agreed either by their words or by their words, then these rules will not apply. However, if they did not have any specific agreements with respect to when property in goods will pass, then these rules must be applied. Okay, performance of contract. Any question with respect to passing of goods, passing of property? Any question? Okay, so no question. Let's continue. Performance of contract. So in contract law or in sale of goods, in any contract law, business law, when we talk about performance, it's not when people come and sing and dance, except that is the subject matter of the contract, except that is what the contract is meant for. Performance simply means when the party does what he said he would do. When the party does what he said he would do. Performance of contract entails when you accept payment, when payment is made, when acceptance happens, when the person accepts, delivery, when payment is made, when delivery happens and when acceptance of, happens. Section 27 provides that a seller has the obligation to deliver goods, and the buyer has the obligation to accept the goods and to pay for them. So both parties have their own responsibilities, things that they're supposed to do. For the buyer, for the seller, no, for the buyer, his own is to accept the goods when they are delivered and to pay for the goods. For the seller, his own duty is to sell the goods, is to deliver the goods. So number one, payments. Section 28 of the Sale of Goods Act provides that payment and delivery should take place at the same time, right? Unless the parties agreed otherwise. Section 29 sub 5 provides that the seller bears the expense of putting the goods in a deliverable state. So let's start with the first one. With respect to payment, whose duty is it to make payment? It is the duty of the buyer to make payment. And this section is saying that when the buyer makes payment and takes delivery, what this section is simply saying that payment and delivery should happen at the same time, should take place, except where the parties decide otherwise. So the parties could decide that payment will be made in a future time, but delivery will be made first, right? Or that delivery will be made at a future time, but payment will be made early. But if they don't have any specific agreements with respect to payment and delivery, this section expects that payment and delivery would happen at the same time. This section also, section 29 sub 5 also provides that it is the seller who would bear the expenses for putting the goods in a deliverable state. But remember that the law always respects people's agreements. If you guys agree that is the buyer that would be the one to put the goods in a deliverable state, then that is what will happen. But in the absence of any express agreement, the person who has the responsibility to put the goods in a deliverable state is the seller, and he's the one that is also supposed to bear the responsibility for putting it in a deliverable state. Acceptance. It is the duty of the seller to deliver the goods to the buyer, right? But then it is the duty of the buyer to accept delivery and to make payment for the price of the goods. That one is self-explanatory. To accept delivery, if the seller is ready to deliver and and you are not ready to accept it and you don't accept it, they are ready to deliver, but you are nowhere to be found, you're not performing your duty. Delivery is, so now let's talk about delivery. Delivery is the voluntary transfer of possession from one party to another. So you see that delivery is not about property and goods. Delivery is about possession. So if I come and I deliver the car to you, that both of us have agreed that you will sell the car to me, and we probably agreed that property and goods passed at the time of the contract, it doesn't mean that delivery has happened. Delivery happens when the physical goods are transferred to me, when I get possession of it, or when, it could be physical possession where you give me the keys to the car.
Which side?
It could be physical possession where you give me the keys to the car. When you hand over the car to me, or it could be constructive delivery where you give me access to the place where the car is parked. It could be symbolic transfer, where you give me is symbolic, right? You carry these big keys that people give when when there is when someone wins an award, it's just the symbol. So it could be symbolic transfer where they carry that big key and give you, or where they do something symbolic to show that you now have possession. Maybe if it's a house, okay, a house is not goods. If it's like a car or a property, maybe a space, maybe a container, right? And you cut the ribbon. You're giving the scissors and you cut the ribbon. You've taken symbolic, delivery of the goods. It could be by atonement. So with respect to rules on delivery, in the absence of express terms on delivery in the contract, the following rules shall apply. Number one, place of delivery. The seller's place of business or residence of the seller does not have to be the place of business. Okay, this is an explanation. The number one, the place of delivery will usually be the seller's place of business. If the seller does not have a place of business, maybe it's an online shop or an online seller, then that seller's residence would be the primary place of delivery. If the contract is for the sale of specific goods, which to the knowledge of the parties are in some other place, then that other place will be the place of delivery. So if it is a contract for sale of specific goods and the goods are somewhere else, they're probably in someone's shop or someone's warehouse, then that place where the goods of specific goods are would be the place of delivery. But remember that these rules apply only if the parties do not have express, if they did not expressly agree on the place, the time, and things like that. Time of delivery is where the seller is to send the goods to the buyer. The time of delivery is not expressly agreed on. The goods is to be delivered at a reasonable time and at a reasonable hour. So because you're the seller and you're supposed to deliver, and me as the buyer, I'm the one who is supposed to accept delivery, you decide to come at 11 p.m. or midnight to deliver the goods. That's not a reasonable time. So that is not an appropriate time of delivery, except we both agreed that you will deliver it in the middle of the night. Atonement, if the goods are in possession of a third party, the goods will be deemed delivered only when the third party acknowledges to the buyer that he holds the goods on his behalf. So remember that atonement is one of the forms of delivery. That's the last form of delivery that is listed here. Atonement is one of the forms of delivery. And atonement means that, the goods are not in the possession of the buyer or that of the seller. They're in the possession of a third party, right? Atonement is where goods that are on atonement are considered delivered when that third party informs the buyer, acknowledges to the buyer that you see these goods, yes, they are in my possession and I'm holding them for you. I am holding them for you. They belong to you. Whenever you need them, I would give them to you. Or whenever we agreed that I will pass it to you, I'll pass it to you. Atonement is where that third party acknowledges to the buyer that he holds the goods on his behalf. Rules on delivery. We've run out of time. Should we complete the class? Should we complete this part on sale of goods or leave it till next week? Am I talking to myself?
We can leave it to next week, ma.
Next week, ma.
Next week, ma.
All right, no problem. So as I've been talking, you guys, I don't know if you're paying attention or not. There will be tests on sale of goods. You've done tests on contract. There will be, and on the other aspect that was covered by Mrs. Adewumi. I would also administer my own test on sale of goods and on hire purchase when I'm done. So it's important that you pay attention and that you take notes. All right. Thank you, everyone, for listening. See you next week.
Thank you, ma.
Okay, ma.
Thank
Okay,
you,
ma.
ma. Thank you, ma.
Thank you.
Thank you, ma.